10/8/2023.
9/8 affidavit 9/8. Affidavit 9/8.
Affidavit 9/8 status
Affidavit
10.
on 9/8/23 but filed on 10/8.
10/8/2023.
Wherein no statement was made that the petitioner has removed the encroachment or the encroachment has already been removed. However, prior to filing of the counter affidavit, a contempt petition was filed before this court on 25/7/2023, alleging violation of the interim order dated 18/7/2023. In the contempt petition, it was asserted that the petitioner had informed the authority on 18/7/2023 regarding the interim order passed in the petition by annexed to annexed with the contempt petition. But in spite of that, the opposite party in the contempt proceeding demolished the structure on 20/7/2023 and violated the interim order granted by this court. The learned counsel has submitted that.
Just one more submission. The entire recording of demolition has already been placed before your leadership by way of an affidavit. It's in a pen drive.
Evidence news.
Just a submission which may be subject to
The
leadership.
learned counsel has submitted that the recording of demolition proceeding has been placed on record.
Yes,
along with a certificate
under 65B.
65 capital B of
Evidence Act.
Evidence Act, and has submitted that it would demonstrate that the demolition had actually taken place on 27/2023 and not on any date prior to that.
By the respondents.
By the respondents. The learned counsel submits that the act of the respondents in misleading the court is also apparent from the fact that in the counter affidavit filed in the petition on while affidavit dated 9/8/2023, no such statement regarding removal of encroachment was made. However, in the show cause filed before this court on revised affidavit on the same date, that is dated 9/8/2023, a statement has been made that on 15/5/2023, the petitioner
page page 9
paragraph 4
who the removed
page 9
yes, page 10, that on 15/5/2023, the circle officer Jamundi received a report from Amin and inspectors of Anchal that the order dated 22/4/2023 that is order included in the petition that goes, has been complied by the petitioner and the encroachment has been removed by the petitioner. The learned counsel submits that by filing such a show cause, the opposite party tried to project before this court that prior to passing of the interim order, the encroachment was already removed by the petitioner himself. The learned counsel submits that it is completely unexplained as to why this fact was not brought in the writ records, although on the same day the counter affidavit was filed. He submits that under such circumstances, the plea of the opposite party that the petitioner had removed the encroachment on 15/5/2023 cannot be accepted. The learned counsel has also submitted that it appears that the enclosure to the show cause annexure B and annexure C in support of such a statement are manipulated / bad. The learned counsel has submitted that violation of interim order passed by this court itself calls for a contempt proceedings, and he has also submitted that in the writ petition, one interlocutory application has been filed for compensation.
Addition of prayer 9676 of 2024 IA
Through IA number
76
9676 of
2024
2023, seeking compensation to the extent of rupees
3 lakhs.
3 lakhs, and the interlocutory application and the prayer for amendment has been allowed.
Yes, Your Lordship, by order dated 5/9/2024.
By order dated 5/9/2024, and therefore
27/11/2024.
27/11/2024. The learned counsel submits that appropriate action be taken in connection with the erring officer who have violated the interim orders passed by this court,
Yes, sir.
which is subject matter in the contempt proceedings, and the petitioner be duly compensated for the losses which the petitioner has suffered on account of violation of the interim
Interim
order.
order. I'll be just putting the reliance for judgment if required, Your Lordship.
The learned counsel has relied upon a judgment reported in
2007
2007
15 SCC
15 SCC
688.
688.
State of Bihar versus Rajendra Singh and others.
Para number,
Para number 6 and 7.
para 6 and 7. To submit that violation of interim order also attracts
Contempt proceedings.
contempt.
Even if the main prayer is not followed. May I read you Lordship those paras if required.
It's well known, it's really पढ़ने का जरूरत नहीं. The learned counsel for the respondents to the writ petition and representing the opposite party has opposed the prayer of the petitioner and has submitted that merely because in the contract to which there is no such statement that the petitioner had removed the encroachment much earlier, and such statement has been made in the show cause filed by affidavit on the same date. The same cannot be used to draw an inference that the respondent slash opposite party has been misleading this court in the email. He submits that the fact was brought in the contempt proceedings, considering the nature of proceedings which allege that the opposite party had violated the interim order passed by this court, which had no bearing in the litigation. Very well, the learned counsel has also submitted that if the petitioner is interested in getting the land demarcated by the circle officer in presence of Amin, the opposite party has no serious objection. He has also submitted that this will also help in judiciously deciding the pending enforcement issue. Okay? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that there has been repeated proceeding slash issuance of notice in connection with alleged encroachment by the petitioner with respect to plot number 524
Since 2009.
and the petitioner claims to be owner of plot number 525 and has denied encroachment over the government land.
She is denied.
Consequently, in WPC number 3378 of 2010, the petitioner was directed to file a representation and the circle officer was directed to consider his grievance and pass an appropriate order after granting an opportunity of hearing. The representation clearly reveals that the petitioner was also interested in getting the land demarcated to ultimately end all the disputes. However, the circle officer, though instituted a case on the representation numbered as application number 2 of 2023, did not take any step for on-the-spot demarcation and has passed the improved order dated 22/4/2023. This court is of the considered view that when the petitioner was praying for a demarcation on the spot, the circle officer ought to have ensured that a demarcation is done on the spot before finally leveling the allegation of encroachment against the petitioner. In such circumstances, the action of the circle officer by passing the improved order dated 22/4/2023 does not satisfy the natural justice and requirement. Accordingly, the improved order dated 22/4/2023 cannot be sustained on this road. However, the matter does not end here. This court directs the circle officer to ensure demarcation of the land. कब जाइएगा बताइए, कब कराना है demarcation?
कोई भी डेट्स
Demarcation of plot number 524 and 525 on बताइए कोई डेट बताइए, डेट यहीं से फिक्स through a government Amin.
First week of January,
That will be too late.
the last week of December. Yep.
On 22nd December? On 22nd December at 11 a.m. Right? The report of the demarcation we produced, we made on the spot. हो जाएगा? हो जाएगा on the spot तो कोई दिक्कत नहीं.
नहीं हो जाएगा.
Report of the demarcation we made on the spot, and a copy of the same we also handed over to the petitioner on the spot. Right?
But if they wish, they can also bring their ameen.
वो अपना करेंगे उनको जिसको इसको लाना.
I'll just file my documents. The order may be passed, the report may be passed, considering my documents.
That's right. Pursuant to the report, it will certainly be open to the petitioner to furnish their documents before the circle officer in the land encroachment proceeding which has now been initiated against the petitioner. हो जाएगा?
Yes.
It's the same thing.
Say this, yes.
Which is numbered as
13 of 2024.
13 of 2024. And thereafter, an appropriate reasoned order be passed in the fresh land encroachment proceeding. Correct?
And if it is found that she is actually encroached upon,
One
Appropriate
issue might be
No,
there.
that will be there. Whatever direction it will be passed.
One issue might be there. The counter affidavit was filed in the month of February.
Just
हो सकता है ये matter dispose of हो चुका हो. Encroachment, these are summary proceedings. तो 13 of 24 may be dispose of हो
वो
चुका.
तो आपने तो नहीं बताया. आपको तो इंस्ट्रक्शन मिल जाएगा ना
हाँ,
आपको.
इंस्ट्रक्शन मैंने लिया.
आप पेंडिंग भी बोल रहे हैं इसमें.
ये इससे पता चला जब मैंने इंस्ट्रक्शन लिया, I was informed by my client that there is no structure which has been created और notice हमें मिला नहीं है, we haven't appeared.
खुद कह रही है कि कुछ
आपने खुद ही लिखा है.
खुद
आप क्या
लिखा है.
करेंगे? Supplementary affidavit.
Sorry.
What do you mean? Encroachment case number 13 of
Oh, sorry.
2024.
This encroachment proceeding which was initiated, I got confused with the some other letter. इसमें appear किए हैं, but इसमें order अभी तक communicate हाँ वो
नहीं
नहीं
हुआ होगा ना, हो जाएगा ना आपका. सारा proceeding communicate करके हो
in
जाएगा.
duration.
Even in case the fresh encroachment proceeding has been concluded, the order of demarcation उतना जरूरत नहीं है. हो जाएगा उसमें.
हो जाएगा.
वो
नहीं,
पेंडिंग है ना आपका. आपको नहीं
वो
पता.
नहीं पता इंस्ट्रक्शन.
ठीक है. अगर मान लीजिए पेंडिंग होगा तो देख. ऐसा तो नहीं होगा कि
पेंडिंग ही होगा.
पेंडिंग ही होगा.
हाँ.
पेंडिंग ही होगा.
ओके.
और डिमार्केशन में अगर वो निकल जाता है तो बोल रहे हैं हम हटा लेंगे.
तो हटा लेंगे. The learned counsel for the petitioner has already stated that the petitioner is only interested in plot number 525 and not in plot number 524.
Yes.
And it is a specific case that he has not enclosed any portion of plot number 524.
Yes.
Correct?
Yes.
ये वो तो ऑर्डर में ही है, कोर्ट के
Order
ऑर्डर में
में.
था. वो 524 जो है वो एडमिटेडली गवर्नमेंट प्लॉट था. It's in the order of 2022 itself.
Oh. ये हो गया आपका writ petition.
Yes, sir.
Writ petition is accordingly disposed of. This court has not entered into the merit of the respective parties. Case of the respective parties.
बस वो
So far as
कंपनसेशन वाला प्रेयर रह
You
गया.
just hold on. उसका भी order. Content case civil number 573 of 2024. This petition has been filed alleging non-compliance of order passed by this court dated
18/7/2020.
18/7/2000
2023.
2023. However, wherein till 7/8/2023, a direction was passed not to take any coercive steps against the petitioner pursuant to interim order dated 22/4/2023. A show cause has been filed in this case. Bringing on record a report dated 15/5/2023 said to have been received by the circle officer stating that the alleged encroachment has already been removed in khata number 87, plot number 524. This report is also followed by a memo number 748 dated 19/5/2023 issued by the circle officer and also copy forwarded to other authorities for information and necessary action that the encroachment in khata number 87, DAM number 524 has already been removed. No rejoinder to this show cause has been filed by the petitioner to allege that the documents annexed along with the show cause at annexure B and C are either forged, fabricated or mandated.
In response, though rejoinder was not filed, that pen drive was filed, pursuant to which notices were issued to respondent number 3.
This court is of the view that the core argument of the petitioner is that the counter affidavit filed in the writ petition, while virtue of affidavit on the same day, this fact has not been disclosed, which amounts to suppression of material facts. This court is of the view that merely because this fact has not been disclosed in the counter affidavit filed in the writ petition, the same does not amount to suppression of material fact, inasmuch as in the writ petition the order dated 22/4/2023 was under challenge, and the contempt was relating to violation of interim order. Therefore, the opposite party in the contempt proceedings brought the notice of this court that while report dated 19/5/2023 and letter dated 15/5/2023, the alleged encroachment was already removed, to inform the fact that on the day the interim order was passed, the encroachment was not existing. That's it. This court is of the view that under such circumstances, this court is not inclined to proceed any further in the contempt proceedings and is of the view that contempt is not made out. Accordingly, this contempt case serial number 573 of 2023 is hereby dismissed. So far as the affidavit filed by the petitioner, contempt में तो नहीं फाइल किया, writ petition वो CD.
Pen drive first.
So far as pen drive in the writ petition is concerned, showing that which according to the petitioner shows that the encroachment was, the alleged encroachment was removed on 27/2023 and not any date prior to the same.
By the respondents.
By the respondents. This court is of the view that such evidence cannot be taken into account as the school will not be in a position to identify the property which is involved in the present case. In such circumstances, the prayer for no case for grant of compensation is made out. That's all. डेट डिस्पोजल है कंटेंट स्टॉक आपको डेट दे दिया है 11 बजे पहुंचना
I informed them.
हाँ you informed them
Informed.
it's your duty please
I will
don't-
inform.
अब इसको वो जो नया कहानी मत कीजिए
नहीं डेटफुल
एक चीज और आप लोगों को ध्यान देना चाहिए आपका बड़ा प्लॉट है अगर और भी लोग हैं तो उन लोगों को भी इन्वॉल्व करके साइन वाइन करा लीजिएगा डिमार्केशन में क्योंकि इट कुड बी अ ह्यूज प्रॉब्लम अभी तो सिर्फ इनके लिए क्योंकि ये है इसीलिए इनको बोल रहे हैं बट देयर कुड बी अदर अफेक्टेड पार्टीज
यस
इट विल बी अ ह्यूज प्रॉपर्टी नो प्लॉट नंबर कितना एरिया है तो नहीं पता
बीघा में है
हम लोग को क्या पता आप जानिए अपना डिमार्केशन कराइए और आप लोग का तो पिछला ऑर्डर में तो है ही खाली एनफोर्समेंट केस करते हैं और कुछ नहीं करते डिमार्केशन कराइए वहाँ बैठ के
करवा दें
Complaint is for hearing on order 41 rule 11 item 24 second appeal 353 of 2015.
Judgment of reversion.
Sorry?
The appellant is the plaintiff respondent.
Please respond.
The suit was decreed in favor of the owner. But the first of all, I am saying the general judgment and one small general judgment. Not one non-two not
Just partition suit.
no suit for declaration and recovery of possession if dispossessed pursuant to the order passed by the SDO in a proceeding under section 1
Proceeding under section 1.
for CRPC.
वन 144 CRPC में क्या है डिस्पोजिशन नहीं करते
For 144 CRPC, that the order is exhibited, the SDO has declared the position of the defendant. In a 144, not a 145 proceeding, in a 144 proceeding, it has declared the position of the defendant, although that order is binding for 60 days only as per.
but still you were concerned with your position.
Yes. Because Nanku Moto was one person, man.
Nanku Mehta
A man having two sons, Jhabu and Digu.
Jhabbu
And Digu.
Digu
Digu, D-I-G.
D-I-G-U.
Yes. Digu died leaving behind the widow Birma Motwine. And there was a daughter away who she was blind and she predeceased her mother. She was not married. That is there. And Jhabu has three sons, Mahru, Titu and Mithu.
Mehru
Titu and Mithu.
Titu
And Mithu. There are two Javamandi. Javamandi number 10 is recorded in the name of Birma Motwine.
DT.10
Recorded in the name of Birma Motwine. And JB number 30 is recorded jointly in the name of Mahru, Titu, Mithu, Birma.
Mehru Titu
Mithu
Titu
and Birma. You know, the disputed land in question is JB number 10. You know, before that is in Ganja settlement. Before, during the pendency of Ganja settlement, there was a title suit 35 of 1932, in which the ancestor of the defendant,
1932.
yes, had made objections, my lord, and that was dismissed. That document is Exhibit 2 is on record.
It was dismissed.
Yes, that objections during settlement
This was a
was
partition suit.
no, that
That
was
is-
objections suit was before the settlement proceeding, my lord.
Before settlement.
Yes, settlement ASO has been dismissed. Lord, the defendants, they are claiming the land of Jamamandi
Who are
number.
the defendants? The plaintiffs
They are not related to these persons.
Okay, they are not related.
Not related. They are
Okay,
claiming
who are the plaintiffs?
plaintiffs are, my lord, the son of Mahru.
Son of but it means plaintiffs are the descendants of Jammu.
Jab, yes. And defendants are the alien. They are not the family members. My lord.
Okay.
Now, defendant claimed the land on the basis of its Kurfa of 1937. That is Sada Kurfa
1937.
37. They want to make a claim 12 years before 1949. The Act came to make a case of adverse possession. Therefore, they are saying that 9/5/1937 Sada Kurfa. On the basis of that Kurfa, they are making claim. With the learned trial court had framed 7 issues. The issues, the most relevant issue was issue number 3 and issue number 5 and 6. Issue number 3 is whether the plaintiff have any right, title, interest, share and possession over the suit. This is the issue number 3. This has been decided in favor of the plaintiff by the trial court. In page 21, if you let me permit me to
Then
read.
the property is recorded in favor of Bidma,
Yes, that.
Mahmood,
Yes.
Titu.
Yes.
Then how this Kurfa would be?
Yes, they have fabricated a document, that Kurfa, that has been well discussed by the learned trial court. And the appellate court, surpassing all those documents and the findings, in a mechanical manner, had admitted that Kurfa as a valid, that Sara Kurfa is a valid document.
Kurfa was followed by any rent receipt.
No rent receipt of that. Those rent receipts are in favor of the plaintiffs. And some of the rent receipt, although Mahpati receipt, they have proved also some of the rent receipt, but that has not been properly proved by the persons. Even the trial court is saying that said Kurfa has not been properly proved. May I read only very small portions?
Yes.
Page 21, running page 13, where issue number 3 has been discussed. Lord, in the middle portion, in the lower portion, प्रतिवादी गण की ओर से एक सादा कुर्फानामा प्रदर्शित
क्या पढ़ेगा?
ट्रायल कोर्ट का जजमेंट पेज 21, पेज 13 of the trial court judgment. Internal page 13 of the trial court judgment. Lord, in the lower portion, प्रतिवादी गण की ओर से एक सादा कुर्फानामा प्रदर्शित नीचे में है, नीचे से 1 2 3 4
प्रतिवादी गण की ओर।
Yes, from there I am reading. This is the finding of the प्रतिवादी गण की ओर से एक सादा कुर्फानामा प्रस्तुति किया गया है। उक्त कुर्फानामा अनिबंधित है और उक्त कुर्फानामा में किसी भी गवाह ने आकर उक्त कुर्फानामा का निष्पादन को संबंधित नहीं किया है। इस संबंध में संधापना बंदोबस्त दुमका के तस्दीक नियमावली कंडिका 19 के उल्लेख करना समुचित होगा, जिसमें यह कहा गया है कि कुर्फा लिखने की तिथि की विश्वसनीयता की जांच में बहुत सावधानी बरतने की जरूरत है। इसके निर्धारण के लिए निम्नलिखित निर्देश अनुपालन किया जाएगा, क्योंकि कुर्फानामा जो एक सादे कागज पर लिखकर जमीन का हस्तांतरण होता है, यह हस्तांतरण संथाल परगना रैयती कानून 1949 धारा 20 का उल्लंघन करता है। ऐसी Lord, this your तस्दीक नियमावली
आपका appellate court इनको adverse
position और ये पर इनको दे दिया है। This is the
कहाँ है आपका appellate court का जज?
yes, appellate court मतलब had 5 points ही किए
एडवर्स
हैं.
पोजीशन का कोई इशू बना?
Yes, issue has been बना था.
इशू नंबर 3.
That on adverse position इनका ट्रायल कोर्ट का पोजीशन ये है, फाइंडिंग है कि 1992 में 42 में बिरमा मरी है. तो अगर even if they were in possession from 37 to पहले, that was a permissive position, not an hostile position. That is the finding of the trial court. उस point पर भी है finding. May I read that portion? It is very well described in the trial court judgment.
ये पेज नंबर 17.
Page
इस
number.
प्रकार 1940
Yes, page number 70.
यह स्वीकृत करते हैं कि मौसमात बेरमा मैदान हुए
It is admitted by them also.
1942 में. अपील कोर्ट देखो.
Yes, appellate court finding I am reading. Yes, para 15. Maybe.
पैरा 3 पढ़िए तो प्लेंटिफ का केस है.
Yes.
क्योंकि वो हिंदी वाला था, नहीं पढ़ा.
Para 3.
पैरा 3 केस ऑफ द प्लेंटिफ.
The case of the plaintiff respondent in brief is that the suit land described in Schedule B of the plaint is recorded in the Parcha last survey settlement of Jamamadi number 10 Moja Patal Chapti PS Sarama in the name of Usman Birma Mahmud exclusively.
इसमें नहीं मिलेगा. एडवर्स पोजीशन का प्ली तो डिपेंडेंट नहीं है.
Definitely.
पढ़िए जरा. पैरा 4.
The defendant appellant appeared on receipt of notice and filed written statement containing that the suit as framed is not maintainable nor have plaintiff locus standi to file the suit. In the contended that the defendants are distant relation of recorded tenant Birma Mahmud. They have not shown the what is the relation, distant relation. Further, that she did not die issueless, rather left her daughter, namely Urva Mahmud. Further, Birma Mahmud died in 1942. And not 3 years after Ganja settlements. She was not joined with Mahrukh Titu Mittu. Rather, she lived with Pyari Mahton, Kublal Mahton, who maintained her. Birma Mahton executed Turfanama on 9/5/1937 in favor of Dhaneshwar Mahton and others. And since then, they possess the suit land. It is stated that Birma Mahton executed Panchanama deed 15 post 1350 BS admitting the possession of defendant. The defendant have claimed to have acquired occupancy right under Regulation 3, 1874. It is submitted that the suit had originally belonged to Jodh Pyari Mahto and Kublal Mahto, the predecessors of the defendants, and the land was given out of sympathy as entire land of Dihu Mahto was sold in realization of land. The genuinity of the Bhugat Bandha deed in Baleshwar Mahto in favor of Ghanshyam Mahto is challenged as false, fabricated and concocted. It is submitted that the plaintiff had executed another fake Bhugat Bandha deed in favor of Kameswar Padlek and others who have realized the forgery and executed deed of release in favor of defendant. It is submitted that on application.
एडवर्स पोजीशन.
No,
इसमें कहाँ है एडवर्स पोजीशन?
they have taken the plea. That is not
कहाँ है
the
एडवर्स पोजीशन?
yes. They are saying that
We have
1930.
not taken the plea of adverse
Even
possession.
that is my substantial question that the learned appellate court had passed beyond the pleadings of the defendant. The order has been passed.
They are claiming title over the
Or
property by virtue of Kurfanama.
Kurfanama or
And then
19
they are claiming.
and as well as on the basis of adverse position, that is their in their written statement they are saying elsewhere that 12 years prior to 1949, from 1937 they are in position there.
Finding plans
Yes, finding, appellate court finding.
on adverse position.
Yes. Not para 19 it starts.
क्या बनाए हैं substantial?
Yes. Substantial questions. Number 3, 4. Whether the impugned judgment and decree passed by the learned first appellate court suffer from the basis of error of record, misreading, misconstruing the documents, oral evidence.
So it's a general test समझना. बताइए कौन सी?
Yes, number 6 and 7. And number 11 as well as 8.
Appellate court का finding नहीं है adverse position. एक paragraph में कहाँ पर?
Yes, that I am sure. Para 19.
Para 19.
From perusal of material on record, it transpires that the provisions of Sindhama Tendency Act, the concept of adverse possession does not find place except in case of land in possession for more than 12 years prior to the enactment of Sindhama Tendency Act 1949. The plaintiff witness PW2 Aso Mia, aged 65 years, states that Birma Mahatma resides with Jari Mahatma and Lal, although he is unable to confirm the fact whether any Kurfanama written by her or not. The case of the appellant defendant, that daughter of Birma Mahatma had acknowledged the position of Dhaneshwar Mahatma over the suit land White Panchanama dated 15 corresponding to year 1944, which also find mention in Exhibit C. The execution of Panchanama is also supported by plaintiff witness PW2 Asomia, although the unregistered Kurfanama does not impact any title, but there is sufficient supportive and corroborative evidence put forward by the defendant appellants. Purva, daughter of Birma Mahatma, in the year 15 post so and so has admitted their possession over the suit land and Exhibit C on the record, which goes to show the possession of defendant over the suit land in the year 1983. Now, 83, that dispute arose before the SDO. Exhibit D, which is the unregistered Kurfa, is supported by the fact that the defendant appellants and their ancestors were in possession of the suit land even prior to 1944. By the fact that Purva Mahatma, the daughter of Birma Mahatma, had executed a Panchanama deed, so and so the possession of the defendant on the suit long back in 1350 BC, Bangla Sambal. The defendant witness has also some of the plaintiff witnesses, namely PW Asomia, have supported the fact that Purva Mahatma had admitted the possession of the defendant over the suit land White Panchanama in the year 1944. Even
adverse possession का तो
yes, this is,
rather finding is that they have acquired occupancy right.
Occupancy right, that
occupancy
is
right is not adverse.
They cannot acquire in 1944 में occupancy right they cannot acquire as per Sindhama Tendency Act. They cannot acquire in 1944. There is no provision. Even in your lords may see this Tasik Niyamavali Rule 19, which clearly says how when the Kurfa will be accepted. It is the first time if it is registered, the date of registration. If it is produced in a court, On the date it is marked as an exhibit. It was marked an exhibit in 1997. Oh, there is no such document, and even the trial court has said, given a finding that nobody has come forward to support the Kurfanama. No witness of the Kurfanama, anyone has supported this fact.
No, in the suit also, in
Yes.
the objection suit number 35 of 1992, this
Yes.
Kurfa was produced.
No.
Yes.
Yes, that was therefore that was 32. It was rejected. That claim was rejected at that time.
Maybe, but Kurfa was produced.
Right.
Kurfa was produced even in that case in the 1992.
You know that is also exhibit 2. Your
Exhibit 2?
Yes.
Yes, it is mentioned in
May I read that exhibit 2? The order of the 1932.
How does a person acquire occupancy right under Regulation 3 of 1870?
Occupancy right can be acquired only if there is any valid transfer before 12 years before 1949. Otherwise, it is barred by law. They cannot.
They cannot acquire occupancy right under Santhal Pargana Act.
They cannot acquire that. That is rule 19 of this act.
This exhibit, this Kurfa,
Yes, it is a plain paper. It is sada kurfa, plain paper. It is neither. It has not been properly proved by any person. It is this is the finding. You will also may kindly peruse the finding of the trial court. Very categorically, the trial court has considered all these facts in page 13 and 14. Page 14. Panji. Page 14, it is trial court has very categorically, it has explained everything.
the dependent witnesses has also supported the case of the plaintiff.
Yes. Some of in their cross examination that has also come in the trial court. That is my
So there is no substantial question.
defendant witness has supported the case of the plaintiff.
Yes.
Yes, plaintiff's case has been supported.
The defendant's witness have consistently stated that the suit line is in possession by the defendant
Yes,
on the basis of Kurfa in the year 1937.
37. Yes, that Kurfa has to be proved. That those persons who have proved their age is that on that point also it has been discussed.
The point is that Kurfa has been executed.
Yes.
Right? Maybe that the person who had executed the Kurfa and in whose favor it was there, they might not be alive by this time.
Why not? But how it has to be accepted? That Niyamavali will also be rule 19 may kindly be seen. Because there is illegal transfer by such type of illegal transfer. In order to avoid illegal transfer, rule 19 may kindly be seen of this.
This rule came when?
It was it is an old rule by which the settlement proceeding started.
When?
It is Tasdik Niyamavali. It is said it has been discussed. This is Tasdik Niyamavali as SPT Act. It is rule 19 may kindly be.
अरे इस rule का कोई date है कि ऐसे ही rule है ना कोई क्या चीज़ है इसका कोई date है?
Santhal Tenancy Act, Section 20 barred the illegal transfer of Raiti. And on the basis of Kurfa, such transfer, anybody come forward and said that it has been land is in my possession, and there so far possession also that is permissive possession if that has been discussed by the learned trial court. It is said that since she had died in 1942, and any position from 1942, it cannot be get the ground of adverse position from 1942. They have to establish it from 1937.
That's right.
And before.
Even if she died in 1942.
Yes.
But they continued in possession.
Continued in possession, if they are there,
But prior to that.
not prior to that.
Much prior.
Yeah, but it has not been established by any of the witness, my lord. It has not been established by any document that they were in possession since 1937. That my case is that.
Oral witnesses are there.
Oral witnesses, my lord, they are saying both ways, my lord. May I read the finding of the trial court, my lord? That will. Trial court page 14 onwards, may I read? पेज 14 पंजीयन की तिथि से कुर्फा की तिथि समझी जाएगी। यदि कुर्फा सादा हो या किसी न्यायालय द्वारा उसके तिथि की मान्यता दी गई है तो उसके अनुसार से ही कुर्फा की तिथि समझी जाएगी। यदि कुर्फा सादा हो या किसी न्यायालय द्वारा उसे प्रदर्श के रूप में स्वीकृत किया गया हो तो वो उसे स्वीकृत की तिथि से ही कुर्फा की तिथि मानी जाएगी। कुर्फा के दर्ज की तिथि। कुर्फा अपने आप में जमीन का व्यक्ति का स्वार्थ स्थापित करने का महत्वहीन है। यह केवल एक साक्ष्य के रूप में दखल के संबंध में व्यवहार किया जा सकता है। इस प्रकार प्रतिवादी गण का उक्त कुर्फानामा के आधार पर वादग्रस्त संपत्ति पर जो दावा किया जा रहा है वह कुर्फानामा पंजीकृत नहीं है, न ही किसी न्यायालय में मान्यता दिया गया है, बल्कि तस्दीक नियमावली के आलोक में यदि विवेचना किया जाए तो वह कुर्फानामा दिनांक 1/6/2001 को न्यायालय द्वारा प्रदर्श के रूप में स्वीकृत किया गया। ऐसी स्थिति में उक्त स्वीकृति तिथि ही उक्त कुर्फा की तिथि मानी जाएगी, न कि उस कुर्फा में दर्ज तिथि। इस आधार पर केवल यह निष्कर्ष ही निकाला जा सकता है कि दिनांक 1/6/2001 को जिस दिन यह कुर्फानामा न्यायालय में प्रदर्श अंकित किया गया है उस तिथि से इस प्रतिवादी गण का वादग्रस्त भूमि पर दखल है और उक्त तिथि के आलोक में प्रतिवादी गण द्वारा प्रस्तुत कुर्फानामा संथालपुरना काश्तकारी अधिनियम 1949 की धारा 20 के विरुद्ध है। प्रतिवादी गण की ओर से प्रस्तुत प्रदर्श ए सीरीज ऑफ खजाना रसीद है। इस संबंध में यह कहना है कि समीचीन होगा कि खजाना अदा करने की किसी भूमि पर किसी का स्वार्थ नहीं हो जाता है जब तक कि उसे अन्यथा साबित नहीं किया जा सके। प्रदर्श बी डी ऑफ रिलीज इसके अवलोकन से ज्ञात होता है कि लेखकारी कामेश्वर पत्रलेख वगैरह ने उक्त डीड ऑफ रिलीज के माध्यम से वादग्रस्त भूमि जो उन्हें भूगत बंधा में दी गई थी को इसलिए मुक्त कर दिया क्योंकि उन्हें पता चला है कि भूमि धनेश्वर महतो पिता प्यारी महतो के दखल में है। इस डीड ऑफ रिलीज के प्रतिवादी गण के वादग्रस्त भूमि के स्वाद प्राप्त नहीं हो सकता है और इस डीड ऑफ रिलीज के प्रदर्श बी स्वाद के लिए कोई प्रमाणिक या सुसंगत साक्ष्य नहीं है। अतः इस संबंध में प्रदर्श बी एक महत्वहीन दस्तावेज है। वादीगण की ओर से प्रदर्श 1 से 1M खजाना रसीद प्रदर्श 2 सेटलमेंट एंड ऑब्जेक्शन केस नंबर 35/32 के निर्णय के सत्यापित प्रतिलिपि है जिसमें विद्वान सहायक बंदोबस्त पदाधिकारी देवघर ने वादग्रस्त भूमि पर मुसलमान बिरमा महात्माइन का दखल पाया एवं बिहारी महतो वगैरह के दावे को अस्वीकृत किया गया है। प्रदर्श 3 जमाबंदी नंबर 10 के पर्चा के सत्यापित प्रतिलिपि है जिसके अवलोकन से ज्ञात होता है कि वादग्रस्त भूमि मुसलमान बिरमा महात्माइन के नाम से पर्चा में दर्ज है। प्रदर्श 3 ये जमाबंदी नंबर 13 में पर्चा के सत्यापित प्रतिलिपि है जिसके अवलोकन से ज्ञात होता है कि जमाबंदी की जमीन वादीगण के पूर्वजों एवं मुसलमान बिरमा महात्माइन के साथ संयुक्त रूप से दर्ज है जो इस तथ्य को इंगित करता है कि वादीगण मुसलमान बिरमा महात्माइन
ऐसे नंबर 353 of 2015 the learned counsel for the argument has submitted that the property involved in this case is related to JB number 10 with two recorded in the name of Bhima. The recorded tenant was the one Nanku had two sons, namely Jabu and Diku. And Jabu had three sons, who are the plaintiffs before the court. And Diku died, leaving behind his widow Bhima, who had a predeceased daughter. Thus, Bhima was related to the plaintiffs. JB number 10 was recorded exclusively in the name of Bhima, and JB number 13 was recorded in the name of three sons of Jabu and Biku. Submits that defendants claim the suit property by virtue of an unregistered document, Ulfa, said to have been executed by Bhima in their favor as on 9/5/1937, and primarily on the basis of unregistered document, the occupancy right of the defendants has been declared by the learned First Appellate Court, although the suit was decreed by the learned High Court. The learned counsel submits that Ulfa being unregistered document could not have been taken into account for declaring the occupancy right of the defendants, and the property belongs to the plaintiffs. After hearing the learned counsel for the appellant, the judgment is admitted for final hearing, and the following substantial question of fact. Whether the learned First Appellate Court was justified in reversing the finding of the learned trial court and declaring the occupancy right of the defendants primarily based on unregistered issue notice to the respondents for which requisites under speed post be filed within a period of 10 days from today. Office to track speed post delivery, call for the record from the concerned court. Post this case on nineteenth of January.
By 23rd
स्पीड पोस्ट के साथ वो भी कर देते
खाली स्पीड पोस्ट कर देते
ऑर्डिनरी प्रोसेस कर देते
हैं
ordinary
both process by 23rd हम कर देते हैं
बाय 22 तक लास्ट दिन में क्यों हम लोग ऑफिस को इतना परेशान
अच्छा by 20
by 22nd
by 22nd
इसको रख We are waiting for the orders case. आपका orders में है first क्या है
Substitution करना था मैडम. Last evening I received the instructions. IE is ready order due to bar of 48 hours will not be filed.
कहाँ है आप
IE हम फाइल कर
When did he expire? 2017. Respondent number 3, 2017 में death.
Parent number 8 died on 27/9/2021.
correspondences एक्टिव होते हैं पहले से। अच्छा अभी नहीं हुआ है।
उसमें LCR मंगाया गया था।
ऐसे नंबर 555 of 2016 two interlocutory applications have been filed during the court proceedings which is taken on record. IA number such and such has been filed stating that respondent number 3 has expired in the year 2017. The name of legal heirs have been mentioned in paragraph 4 of the interlocutory application. Let notice be issued to the proposed legal heirs and successors of respondent number 3 for which requisites under speed post and ordinary process be filed by 22nd February. The other IA number sentencer has been filed for substitution of applicant number 8 who is said to have expired on 27/9/2021. The death certificate has been placed on record and Vakalatnama on behalf of the proposed legal heirs and successors has also been placed on record. The interlocutory application will be considered after appearance of the proposed legal heirs and successors of respondent number 3. Notice be also issued upon the respondents on the respondents already on record except respondent number 3 who has expired, in both the interlocutory applications. इसमें भी जाएगा उनको भी नोटिस जाएगा सुनकर requisite same day 5 तारीख office to tax people's delivery post this case on 9th of February. Need to rise the meeting